Good morning to all of you. Today I am presenting my micro teaching topic on right to freedom under the online refresher course Human Right and Social Inclusion, which are conducted by Dr. Babasaheb Ambedkar Marathwada University. Right to freedom. Myself, Professor Sheikh Tarannum, in charge principal of MSS Law College, Jalna. Then what is right to, what is, first of all, what is fundamental rights? The fundamental rights are defined as basic human rights and which every Indian citizen has right to enjoy for a proper and harmonious development of personality. And these rights universally apply to all the citizens irrespective of race, place of birth, religion, caste, creed, color, or sex. The fundamental rights are included in Part 3 of the Indian Constitution, which is also known as Magna Carta, the Indian Constitution. And these rights are called fundamental rights because they are justiciable in nature, allowing the persons to move the courts for their enforcement if and when they are violated. Then the main silent feature of the fundamental rights are which is protected and guaranteed by the constitution, and it is these fundamental rights are not sacrosanct or absolute. It is justiciable, and it can be suspension of fundamental right during the emergency. Then what is then the six fundamental rights are provided under the Indian Constitution: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to property, and right to property and right to constitutional remedy. Then what is right to freedom? Right to freedom, according to the Indian Constitution, refers to the fundamental rights given under Article 19 to Article 22. The aim of this right is to promote the ideals of the liberty held by the preamble in newly independent India in order to remove the inequalities amongst the individuals and to entitle all the individuals to a dignified life. Then Article 19 of the Constitution, which are guaranteed. There are the six type of the freedoms are guaranteed under Article 19 Clause 1: freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence, freedom of profession and trade. Earlier, these were a seven freedom, but one of them, namely right to acquire, hold, and dispose of property, was omitted by the 44 Amendment Act 1978. And these six freedoms are only available to citizens. That is only the natural person having the status of citizenship under a law. It means the determination of citizenship under the Part 2 of the Constitution is a condition precedent for claiming rights under Article 19. Alliance, foreigners, juristic persons, registered companies or societies are not entitled to such rights. Then another freedom, that is Article 20 Article 20 of the Indian Constitution, and this Article 20 provides protection to the person in respect of the conviction in certain offenses. It guarantees mainly three types of protection, namely ex post facto laws, double jeopardy, self-incrimination. This ex post facto laws are those laws which provide the punishment for the act which was lawful when it was done and later declared as an offense. And clause 1 of Article 20 prohibits a retrospective criminal legislation, that is, no law can be made prohibiting the act with retrospective effect, and hence no person shall be subjected to a greater penalty or punishment than that which could be inflicted under the law in force at the time of commission. Then double jeopardy, the maxim nemo debate bis vexere states that no man shall be brought into a danger for one and the same offense more than once. Even this American Constitution, this principle was given in Fifth Amendment, which declares no person shall be subject for the same offense to be put twice in jeopardy of the life or limb. But the Indian principle of double jeopardy is quite different from the principle followed in British and in America. America and Britain, the bar applies to second prosecution irrespective of the result of the first prosecution, whether the accused was acquitted or convicted. But in India, to apply the provision laid down in Article 20, it must be shown that the accused has been prosecuted before the court and punished by it for the same offense for which he or she is prosecuted against. Hence, if there is no punishment awarded, there will be no application of Article 20. Then protection against the self-incrimination. This clause declares that no person can be compelled to be a witness against himself or herself. Three components of these provisions are: the person must be accused of any offense, protection against self-incrimination, and there must be a compulsion to give evidence against himself or herself. Then the next freedom is the Article 21 of the Indian Constitution. No person shall be deprived of his life or personal liberty except according to a procedure established by the law. And Article 21 is most important fundamental human rights provided in the Constitution, which makes a mark for all the other laws in the country in defining its scope, justice, defining its scope. By the term life, something more is meant than mere animal existence, and inhibition against deprivation extends to all those limbs and faculties by which life is enjoyed. This Article 20 was interpreted laid dormant until the arrival of the case of Maneka Gandhi versus Union of India, and which broadened its scope, brought greater transformation in judicial attitude towards the protection of life and liberty of the individual. And it lays a number of propositions to make Article 21 more meaningful. And the new interpretation of this Article 21 has provided the Indian jurisprudence was fascinating development of rights, and it has now become the heart of the fundamental rights. Moreover, it also has provided recognition to various directive principles of state policy, which were essential to be included as a fundamental right. Then, Article 21, the state shall provide free and compulsory education to all the children of the age of 6 to 14 years in such a manner as the state may by the law determine. And the Constitution 86th Amendment 2002 inserted this Article 21 of the 21A in the Constitution of India. And the Right of the Children to Free and Compulsory Education Act 2009, which represent the consequential legislation envisages under Article 21A, means that every child has right to full-time elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. Then the last freedom, that is the protection against the arrest and detention. And this Article 21 provides the various safeguards for the arrested person to ensure their rights against arbitrary arrest and detention by the police. And it also authorizes the legislature to make the laws on preventive detention. And the right of the this Article 21 given the four main rights to the arrested person, that is right to be informed of the ground of the arrest, right to be defended by a lawyer of his own choice, right to be produced before a magistrate, and no detention beyond the 24 hours except by the order of the magistrate. And thus, and the lastly, I conclude that the quotation of the Nelson Mandela, for to be Free is not merely to cast off one's chain, but to live in a way that respect and enhances the freedom of the others. And therefore, right to freedom not only means that one is not bound by anyone, but it also includes freedom from any kind of pressure, whether physical or mental, in any facets of one's life. Also, while enjoying our rights of freedom given by our Constitution from Article 19 to 22, we should not forget that one's rights end at the moment where others' rights start. Hence, there are reasonable restrictions to check the irrational and illegitimate use of one's freedom. Thank you.